2.0 Podcast Episode 7.
Privacy and Confidentiality.
Bioethics 2.0 Podcasts, Episode Guide. This is podcast number 7, regarding privacy and confidentiality. You can find this information in Fletcher's Introduction to Clinical Ethics, Chapter 7. Additionally, this information can be found in Schroeder's Practical Ethics for Nurses and Nursing Students, a short reference manual, Chapter 6.
This section of the podcast, we're going to talk about some of the differences between the concepts of privacy and confidentiality. The right to privacy is a fundamental and basic human right, and privacy is integrally connected with our own personal integrity. It's basically a form of personal autonomy, which is essentially the ability to control information that others have about us.
Confidentiality is the process of keeping secret, intimate knowledge that a patient has entrusted to a physician. Confidentiality protects the patient from harms that may be caused by releasing intimate data that has been disclosed to or observed by the clinician.
Some of the philosophical underpinnings of the concept of privacy and confidentiality have to do with the notion of negative and positive rights. To describe these things, a negative right is essentially the right of non-interference, basically the right to be left alone. It's a basic prerequisite for self-determination and moral agency. In contrast to this is the positive right. The positive right to privacy involves basically a person's prerogative to control access to and distribution of information about him or herself to clinicians. And as Rebecca described, confidentiality is one of the mechanisms by which a person's right to privacy is recognized and honors. And it reflects the premise that individuals should be able to exercise control over certain information that pertains to them. Essentially, this information is their moral property. So basically, as Rebecca described, confidentiality is a form of promise that is based on a trust relationship. Without the presumption of confidentiality and the underlying foundation of trust, true intimacy between persons would not be possible, nor would a quality clinician-patient relationship.
So why is confidentiality important? The nurse safeguards patients' rights to privacy by protecting information of a confidential nature. Also, the nurse safeguards the patient's right to privacy by judiciously protecting information of a confidential nature, because without such assurance, the patient might be unwilling to divulge information critical to his or her care. The basis for principles of confidentiality. Confidentiality respects the individual's privacy and autonomy, and it builds upon the special trust inherent in a nurse-patient or physician-patient relationship. The confidentiality agreements between such authority figures is also good for the society, and it prevents harm to the patient. Exceptions to the rule. There may be legal exceptions to confidentiality that necessitate divulgence. These include testifying in court, reporting communicable diseases, reporting child abuse, spouse abuse, or elder abuse, reporting gunshot or suspicious wounds, and reporting for workers' compensation cases. Nurses are required to report gunshot or suspicious wounds if there is a reasonable cause to believe that the wound occurred as a result of a crime. So why would a nurse breach confidentiality? And when is it acceptable to breach confidentiality? There are guidelines to breaching confidentiality, and one would do so when there is a high probability of serious physical harm to a person, a likely benefit that would result from breaking confidence. For example, a harm can be prevented to himself or herself or others. The breach is the last resort. Persuasion and other approaches have failed. Or the breach is generalizable. It is reasonable for a nurse or doctor to breach your confidence and treat you in the same way if you were the patient. There may be situations in which there is an ethical demand for a nurse to consider breaching patient confidentiality. Such a problem may occur, for example, when a patient who is HIV positive refuses to tell his or her spouse or significant other of the infection, thus placing the other at risk of contracting a lethal disease. The nurse who is aware of this is in a bind between duty to the patient and the stronger ethical demand to warn an unsuspecting person of significant danger. Such a breach is justified when all of the conditions apply.
As Rebecca mentioned, there's actually a fundamental legal and ethical duty to warn. We'd like to describe a little bit of the background about this duty to warn. It stems from a 1974 legal case in which the duty to warn third parties who are at risk of injury by a patient was established in Tarasoff versus Regents of the University of California. Judge Marshall actually wrote a very interesting quote that I like to use to sort of denote when the differences between the negative and positive rights to privacy and confidentiality exist. Marshall said, "The protective privilege that one has basically to privacy and confidentiality ends when the public peril begins." So there are actually criteria that exist when you can make an ethical and legal warning to initiate this Tarasoff warning. And I'm noticing that our slides are a bit misnumbered here. We apologize. So there should be a number 1 and number 2, not a number 3. So when violence is actually foreseeable, and this basically has to do with the background of the particular Tarasoff case. Basically, a student at the University of California told his psychiatrist that he was going to murder his girlfriend, Tatiana Tarasoff. So when a clinician believes that violence is foreseeable, then that is a situation where you have ethical and legal justification to initiate a Tarasoff warning. And when violence is foreseeable is determined by 3 factors: when there's a known history of violence, when there's a threat to a named or clearly identifiable victim, and a plausible motive exists. So if 2 of these particular factors exist, the standard is met, and a clinician may initiate a Tarasoff warning. There is the legal and ethical duty to warn. If only one of these criteria is met, it's really a situation where you could go either way with it, and clinicians should get ethical and legal guidance in terms of initiating a Tarasoff warning. The other factor that's very important is the clinician has to have enough control over their patient to prevent the violence, such that the patient is in an institutional setting or can actually be committed to an institution to make sure that they don't commit violence. Now, how far does actually Tarasoff extend? Although the case was tried in California, this is an instance where a legal case has helped determine what the ethics is. And the principles from Tarasoff have been extended to the general United States healthcare setting and are widely acknowledged in bioethical and legal discourse. The question then becomes, however, under what circumstances is it acceptable or permissible to violate patient confidentiality to protect someone else or the public good? And this is the ethical dilemma that clinicians are going to need to grapple with to determine how far Tarasoff can extend to their clinical practice.
Electronic confidentiality. As more patient records are maintained electronically, nurses must be much more diligent in ensuring confidentiality of those records. Today, a nurse must be careful not to allow patient information to be publicly visible from a computer screen. Credits.
Hi, I'm David Perlman, Senior Lecturer, University of Pennsylvania School of Nursing, Associate, University of Pennsylvania Center for Bioethics, also President and founder of E4, Eclipse Ethics Education Enterprises, and creator of the Crucial Choices learning format.
Hi, I'm Rebecca Cha. I'm currently an undergraduate student at the University of California, Los Angeles, UCLA. I'm a philosophy major with a pre-med emphasis, and I am currently the summer intern at the University of Pennsylvania Center for Bioethics. Questions, funding, sponsors, and disclosure. For questions about this podcast's content, please direct all questions to David Perlman at the University of Pennsylvania School of Nursing. His email address is perlmand@nursing.upenn.edu. Again, that's perlmand@nursing.upenn.edu. This podcast is part of a series of podcasts designed for Nursing 330, the undergraduate ethics course at Penn Nursing. Funding for this project comes from Penn Nursing and support from the Penn Center for Bioethics, the Weigel Information Commons at Van Pelt Library, the Ormandy Music Center at Van Pelt Library, and E4, Eclipse Ethics Education Enterprises. Disclosure.
Hi, this is David Perlman once again. I am the president and founder of E4, and as part of this entire project, E4 has licensed the ethics education learning format called Crucial Choices for use in other parts of this project. For more information, please consult E4's website at www.e-4.org. That's www, the letter E, -four.org.